all that process, so just jump
Yeah.
in and
Okay, let me get this loaded here.
you can see it just fine. Looks good.
Okay. All right. So, like Dan said, my name is Parker. Clint, you know me, and Hunter. Um, it's good to meet you. All right. Trying to my presenter view here. Okay, so my project is titled Property Rights and Takings, a critical resource for landowners and development professionals. So I work in land development. I work for an engineering company, and part of our service, probably one of the main things that we do is we help people develop their land. We do the entitlement work for them, meaning we get them from point A to point B with being able to build whatever they're trying to build. And so we work with local government entities, we work with state government entities, sometimes federal government entities, and we work with the general public a lot too. And as infrastructure and land itself becomes kind of scarce and kind of insufficient where we need it, the attitude towards developing the land becomes pretty negative. Recently, we had a project in South Jordan where it's a big project, but the neighbors came to the city council meeting when we were trying to get it rezoned, and they're accusing us of all sorts of just horrible, terrible things, literally telling us that we were going to hell for just trying to build some homes. Direct quotes. And a local city councilwoman here recently stated that she believes developers are raping the land. So the attitude towards property rights and land development is really becoming to a point where people believe that property owners and developers, they owe something to the public. The public is entitled to something in exchange for demand for this development. And my goals with my capstone project is that future professionals, whether they be government employees or whether they be like surveyors or people that do the same kind of thing that I do, that they can sort of be educated on property rights, and that hopefully we can work better together on these things, because it is really, really challenging when people don't understand what rights property owners have. It is really, really challenging to move things forward. It costs people tons and tons of money and time. And yeah, so James Madison stated that as a man is said to have a right in his property, he may be equally said to have property in his rights. Where an excess of power prevails, property of no sort is duly respected. No man is safe in his opinions, his person, his faculties, or his possessions. So I know it's a lot of words, but what this essentially means is that without property rights, we don't really have any rights at all. All of our rights are dependent and boil down to our property rights. Luckily in the United States, we have pretty strong property rights. I don't know if you guys have had your global class yet. What is that class called, Dan? You're muted, but anyways, in that class, sorry, what?
It's called, I think it's the one you're talking about, the Global Professional Ethics and Liabilities.
Yes. I don't know if they've had that yet, but in that class, you'll learn about land tenure, and you'll do a report on land tenure in another country. And I did mine in the Congo, and it was immediately evident how important property rights was for people's rights in general, and for the well-being and welfare of people and the economy. In the Congo, they essentially just don't have any property rights at all. Your only option is to essentially borrow property rights from the government for a limited amount of time or squat somewhere on land. And Congo should be one of the wealthiest countries in the world because of the amount of resources it has, but it's one of the poorest because people just don't have the ability to have property rights. They can't, there's just no real process for it, and there's so much corruption. So property rights in the United States are defined by the Constitution. The Fifth Amendment of the Constitution says no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. And Amendment 14 says something very similar. Essentially just means that if you own property, it can't be taken from you without you being given something in exchange that's fair. And the way property rights works in the United States, and you've probably heard this in some of your other classes, but it works like a bundle of sticks or a bundle of rights, meaning that you hold certain rights when you own property. And some of those rights are the right to manage, the right to enjoy, the right to restrict. Those are some of the things that you hold when you own property, but you may not hold all of the rights at the same time. And that's where easements come in. That's where rights of way come in. That's where certain takings come in. And that's kind of what this is about. So the state has determined, has made several laws regarding property rights and property rights in development. Of course, there's the Constitutional Takings Act, which essentially just reiterates what the Constitution says, Private Property Protections Act, and the Land Use Development and Management Act, which is the one that has the most to do with development and eminent domain and takings and those things. And the purpose of that clause, which is called the Takings Clause, is to prevent the government from forcing certain individuals from essentially bearing the burden of providing public services and infrastructure alone when those services should be provided by the public as a whole. So takings, what is takings? So a taking is any time private property is damaged or has its value lessened in a significant way by a government or public entity, or when the property owner's rights to enjoy their property or use their property in that bundle that we talked about is interfered with by a government or public entity. And that's called a taking. And takings can take many different forms. Some are really simple and some are really complicated. The most simple one, I think, is eminent domain. Essentially with eminent domain, we'll talk about it later, but the government just essentially buys your property at fair market value. So that one's pretty simple, but then you get into regulatory takings, physical occupation, damaging, and development exactions. And these things have a lot of nuance in them and a lot of sort of complexities that people don't understand. And sometimes when they face an issue, they just think that they have to just do everything that they're told, or they have no rights in these because essentially a government entity is just demanding something from them. And they don't understand what to do. Types of property that can be taken is physical land and other forms of property interest, which could even just be money. It could be construction of some sort of utility or something, or infrastructure. And there's 6 elements included in an illegal taking. So it's an action to damage, occupy, or interfere with private property by a government or public entity for public use without providing just compensation. And I'll get into some of that in a minute. But that's the gist of takings. So what's considered public use? The takings clause says it has to be for public use. I just said that it has to be for public use. Public uses are defined by the state, and it's things like roads, obviously, utilities, pathways. There's a lot of different things, but those are kind of the basic ones. And like I said, in order for a property to be taken, it has to be for one of these things that is defined by the state. Otherwise, it's illegal. Yeah. Sometimes in land development, you will want to give some property away for a public use, because say you're building a subdivision, you don't want to maintain ownership of the roads, you and the utilities or whatever in them. You want to give them to the public entity because you don't want to pay taxes on them. You don't have to pay to maintain them. That's a public use, and that's not really a taking, but that's one example of a reason why you may want to give property away for a public use. And so takings or losing property for public use is not always a bad thing. Sometimes it can be beneficial to you as a property owner. And then sometimes public use can be really specific, like a private person or private individual can actually exercise takings for certain public uses related to water. So if you had water on your property under certain circumstances, that person could gain a right of way or gain an easement or of some kind in order to access that water. But in either case, you would be entitled to compensation for that. So don't let anybody tell you that they can just cross your property for water and not give you anything else in exchange. You are entitled to compensation for that. Oh, well, let's go back. So in our project in South Jordan, so it's kind of complicated. We have an aquifer that goes across the property. This property just has so many easements on it. And so part of that bundle of sticks we don't own, or our client doesn't own, just because of how many easements are across the property. And there's an aquifer that runs across the property, but in that same location, there's a historical easement there where a farmer has been accessing water. And the aquifer people essentially told us, well, you're not allowed to access this property because we have an aquifer here. You're not allowed to improve this property. And we essentially just told them, well, we have a water easement here essentially, or this farmer does, and he has the right to access it according to these laws. And as soon as we talked to the right people, they were like, oh yeah, you're right. You know, we understand. And so sometimes just knowing this information and talking to the right people about it without getting, involved illegally or anything, sometimes just knowing the information and knowing the law, knowing your rights, can be really, really beneficial to you as a property owner or a developer. And then what is just compensation? What does that count for? What does that mean? So just compensation essentially boils down to money, usually, and it's supposed to put you in a place to where you are in the same financial state as you were before the property was taken. This is kind of controversial because the fact that you weren't selling the property in the first place kind of implies that the property has more value to you than it does at fair market value, or it does with what you've received. So that's one thing to think about. If you're a government entity, this property may have more value to the person than it does to you or to somebody else. And then the amount of compensation is determined by a few factors. Fair market value of the property, which is determined by an appraisal. And you have the right to to accompany the appraiser and to speak with the appraiser. It's not some under the rug deal that happens between the government and the appraiser. You are totally involved. It's also determined based on the fair market value of any improvements on your property, severance damages, offsetting benefits of severance damages, project damages caused by construction, or temporary use or occupation during construction. And that's a lot. So severance damages essentially means that, let's say you own a home and there's construction going on, and or part of the property is being taken, but part of the property that remains is also damaged. And so you would not only be compensated for what was taken, but for the remaining property that was damaged. And then that damage can be offset by the benefit of the public improvements going in. So say you own this property, part of it's being taken, but your house or a structure is on part of it and part of your own. Well, the improvements they're putting in is benefiting you to a certain degree to where you break even anyways, or they can subtract what you're benefiting from the public improvements from those severance damages. And then also during that project, if any damage is caused to your property during construction, or if you can't access your property for any reason or access utilities or something like that, you are entitled to compensation for that. And then when is compensation due? Compensation is due whenever the property is determined to be taken by the taking entity. And that's kind of different just depending on the situation. Yeah. Any questions so far? Okay. Oh, and I also have to state that I'm not an attorney. So as you can see at the bottom, I've disclaimed that I'm not an attorney. This is not legal advice. This is just legal information. So if you feel like at work you're dealing with a situation like this, you should contact an attorney and get advice from them. This is just information for educational purposes. So, eminent domain. Eminent domain can also be referred to as condemnation. And this is kind of the one that we learn about in school, like in high school or whatever, about when we're taking our civics class, because it really is pretty simple. Usually, like if the government is trying to build a road or extend a road or intersection or something, they usually need to take a larger right of way. And so property will just be taken through condemnation or eminent domain. I'm working on a project right now where they essentially bought a house in order to fix an intersection, and they tore it down through eminent domain. And this process is simple in theory. It can take a long time because you can negotiate throughout the entire process your cost and what you get in exchange and when it happens. And so this is sort of that most simple example of a taking. But the condemning agency must follow certain federal and state laws regarding eminent domain, and that's all public. So if you're facing an eminent domain process or problem, you can look up the requirements, you can make sure that the process is being followed, you can see your rights, and that's all defined by the code here, the state code. So yeah, eminent domain it can be good, it can be challenging. Obviously, like I said earlier, you may not want to sell your property, and so that can be really disappointing. It can be emotionally challenging, but it's just the way it is, and you have certain rights when it happens. Permanent physical occupation. You may own property, and the government decides it needs to set up some sort of operation or facility or structure or something on your property, and you are entitled to compensation when that happens. And according to a court case that happened in Los Angeles and the county, or I'm sorry, Los Angeles County versus Glendale, you are entitled to compensation even if that's a temporary thing. So that's the name is kind of misleading, where it says permanent, but yeah, this one is pretty basic, I think. And it's sometimes referred to as inverse condemnation because it's essentially the inverse of eminent domain, where the property's not really being taken from you, it's just being used without your permission, essentially. So regulatory takings. So I think regulatory takings are the most complicated form of taking because they are so challenging and difficult to prove. So a regulatory taking occurs when a public or government entity adopts certain regulations which extensively hinder or cause a property owner's use and enjoyment of the property to be cut short. Or when compensation is owed when these regulations are so extensive that the government has essentially taken possession of the property. So they may not want to go through eminent domain, but they may also not want you to build something. So they may just adopt certain regulations that prevent you from building something. And that is considered a taking because it is essentially the same thing. But it's difficult to prove because you essentially have to prove that your property has lost all economic value. And usually land has some economic value almost always. And I don't know how you prove that. It's very situation specific. But also, if there's some investment backed interest in the property and the government is interfering with those investment interests, that can also be an argument for a regulatory taking. And so really anything, as long as it devalues the property extensively, could be considered a regulatory taking. Even zoning ordinances, like I have listed here. If a zoning ordinance is too strict, you can't. Cities are always trying to change zoning ordinances in order to fit or exclude what they don't want. And sometimes it can be so strict that essentially building what they do want, it just isn't viable. And so that could be considered a regulatory taking. Damaging. So damaging is essentially when a government activity damages your property on a reoccurring, permanent, or continuous basis. So if you have property and the government is constantly working on it repeatedly, or has some sort of, it's kind of similar to a physical occupation. If your property is just being damaged reoccurringly by the government, then you're entitled to a compensation. Except it has to essentially be definite and detectable by the senses, meaning you have to be able to like see it essentially, or the law says detectable by the senses. I assume that just means see it. I don't know how you could taste it or anything, but it has to be perceptible. The damage to the property must be perceptible, that the value of the property has been hurt by this activity. And it has to be special to the property. It can't be something that affects the general public as a whole. It has to be specific to your property or you and your neighbors. It can't, and it also can't be a result of an act of nature or an act of God. It has to be actual government activity. Development exactions. So this is the big one for me because this is what I deal with almost every single day at work. Exactions are essentially, they can be a good thing and they can be a really bad thing. So the purpose of exactions is to be a solution for a problem that development is causing. And it's good when it's legitimate. When a development comes in And it's going to add burden onto the general public, onto infrastructure. It's going to add traffic. It's going to add sewer burden. It's going to add water demand. It's going to add all these different things. And it's not fair for the entire public to just pay for that because they were already there. And so it's not really fair for them to just have to dish out this extra cost for your house. And so a development exaction is a way to provide infrastructure by a developer or from a developer to the general public in a fair way. And this can be in impact fees. This can be in you might be required to build the infrastructure yourself. It could be in land dedication, connection fees. It could just be monies to pay somebody else to build it, and then application fees and review fees. And these are very, very common. I think they're probably the most common form of taking, but they're not necessarily illegal. They're usually, well, oftentimes they're very legit. And any local entity can apply these exactions. That means cities, counties, state, sewer district, any sort of governing body that has some sort of power over your project can apply these exactions. And there are certain standards for these exactions to be legit. Let's see. So in order for an exaction to be legit, there must be a link between the exaction and a legitimate public interest. So that means that the exaction can't just go pay for somebody else, a neighbor or something, or a private person to just gain something. It has to be a benefit of the public. It has to be a legitimate public interest, like we talked public uses earlier. And then also the exaction or the solution to the problem must be roughly equal or proportionate in both nature and extent to the impact or the problem caused by the development. So the exaction can't be some absurd thing in order to fix some little thing. They have to be roughly equal in both nature and extent. And what that means is in nature, that essentially means that the exaction is a legitimate solution to the problem being caused by the development. So if it's a drainage problem, it must be some sort of drainage solution. It can't be something completely unrelated to drainage. And then in the extent, it means that the exaction is roughly equal to the cost that it would be for the public to pay for the solution. And the government entity or the taking entity holds the responsibility to prove that the exaction meets these requirements. So they can't just demand anything they want and then you ask, okay, well, how does this meet these requirements? They have to provide that evidence. It's not your responsibility to prove it or whatever. They have to do that.
Parker?
Yes.
These do not require any kind of representation
What do you mean?
by the public, by individuals. They don't require any kind of, what do you call it? It's not done by the legislature. It's done by a local entity, and they can decide this is what the impact fees are going to be. Yep. This is what the connection fees are going to be. So they make that determination. Obviously, they have to meet these standards, these requirements of an exaction, but they don't have to get permission from the public in a vote type of format. So it's not. We don't have representation for this. They can just go ahead and do these things. Isn't that correct?
Yeah, a city council could apply an exaction. They could say, okay, well, as a condition for your project approval, you need to provide us this. A city council can do that. But it needs to meet the requirements. But usually it's employees essentially that do this, or administration that come up with these exactions. So planners, engineers, even inspectors can demand exactions. And whether or not they know what they're talking about is one thing. And some exactions are in the code. Like it could be in the code that says, okay, for a development to come in, and fees usually are in the code. So they usually say, you know, this, you have to pay this amount of fees for this calculation for your property. That is in the code. So technically that is, that's a legislative decision, if anything that's in the code. But like a planner could apply an exaction. He could say, no, you have to do this in order to build this project. Yeah. And
I mean, it can be as simple as like for on my property here, when I've got this permit that I'm working on right now, they required me to put in a backflow preventer valve.
Yep.
That's essentially an exaction. I have to pay for it, and they're requiring that I do it, and they're going to come and inspect to make sure that it's done and done correctly. But I had to pay for all that, but they said you have to do it.
Yeah. And it gets kind of muddy because, like, I feel like their standards sometimes, you have to follow their standards, and sometimes their standards, I think, are a little bit overboard. And so I think there could be an argument occasionally there that, I mean, it's adopted, so you have to follow it, but it may not be roughly equal to the problem you're causing. Like, if they want you to have certain meters, well, you don't really need to have the fanciest meter or something, but that's their standards. So, and then also, we have a project in Tooele that we did recently, and the city engineer just straight up held our project hostage over an exaction. Essentially, he didn't want to take it to city council. He just said, we have this problem and it's our fault. We know it's our fault. It's not a problem caused by your development. It's an existing problem that we screwed up, but we're requiring you to pay for it. And that would be an illegal exaction. And sometimes, and I'll get into this later, sometimes it's just worth it to just do what they're asking. And which is really frustrating, but that's just the way it is sometimes. And in this case, we negotiated, and it just reached a point where we just reached an agreement and just paid for what he wanted, essentially. And there was no city council involved. I mean, he had to get funding for his portion on the exaction from the city council, but it was just him just saying, well, we need you to pay for this, and that's the way it is. We won't approve your project until you pay for this, essentially. And you have, the only representation you would have is an attorney of some sort, so to represent you. You could always request a meeting in front of the city council. You could always request a meeting and show up. I mean, they're public meetings. You could say, look, this is what's happening. We don't think we're being treated fairly. And then you essentially have that representation. Yeah. So in order to recognize whether an exaction is legitimate or not, whether it's legal, there's essentially this 5-part test that we use. And it's, does the exaction protect a legitimate public interest? Is due process requirements being followed in the process? Like with that example with the engineer, I don't think due process was being followed very well. Is there a direct link or nexus between the exaction and the burden of development? My example, certainly not. It had nothing to do with our development. Is the evidence that the exaction is roughly equal in cost to the burden caused by the development? And that's just calculated. You can have an engineer calculate that. You can have a construction company calculate that, just whatever it is. And then is the exaction the least intrusive solution to the problem? This is a big one. So like I was saying, sometimes the city will say, well, your development is causing this problem and we need you to fix it. But then they'll require some solution that is way over the top, like I was saying earlier. And so the exaction needs to be the most minimum to solve it, because otherwise the city or the government is essentially gaining something else out of it. They're gaining something nicer than they really need. And obviously it needs to work. It can't just be not a legitimate solution. It needs to be a legitimate solution, but it needs to be the least intrusive solution to the problem. And you can, when you're dealing with things like fees, this doesn't exactly match up correctly. Like with application and review fees, they're crazy. Review fees in South Jordan, review fees were like $250,000 to review a plat. And I mean, it didn't even cost that much for us to make the whole project. And so you have the right to go to the city and say, I don't think these fees are legit. Can I request a schedule or like a fee schedule of how these were calculated? And they have to provide for you each individual fee, how it is calculated, and what studies or reports they used in order to calculate those fees. And they have to provide that like within 10 days. And so that's really useful for connection fees, impact fees, application review fees, any fees. And that's, I don't know, I think that's probably the easiest solution in order to verify that you're not getting taken advantage of. So. And so in the state of Utah, we are so lucky because we have the Office of the Property Rights Ombudsman. The Office of the Property Rights Ombudsman was created to educate and assist the public in property rights issues. Their service is free, and they will offer you advisory opinions on whether or not your situation is a legitimate property rights issue or not, and they offer free mediation as well. They will educate you on what rights you have, and they don't represent you like in court. They won't send demand letters or anything, but they will educate you and they will assist you in working with the public entity that you're dealing with. They'll mediate and they will help you communicate. They'll help you negotiate. They're such a valuable resource. I contacted their office, received such enthusiastic response from them. I spoke with their lead attorney. He is so passionate about the office and what the office does. He was so insistent that anybody contact him, anybody contact their office with any questions, even if no matter how minor or how big, he just wants to help. The service is free. It is the most valuable service or resource we have for property rights in the state. And unfortunately, all states don't have this. And I think all states should. We have a project in Wyoming, and Wyoming doesn't have a property rights ombudsman. And the city council or the planners there just straight up told us that they would decline any application that we submitted related to our project just immediately. They would just decline it because they didn't think that they had the proper sewer capacity. But either way, our client had followed all laws. And so he has a right to go through the development process and receive a conditional approval. Even if they don't have sewer capacity, he can get a conditional approval. That's his right as long as he's following all the laws, which he is. And unfortunately, Wyoming has no property rights ombudsman. So there's no way to mediate this without hiring an attorney. So is it worth it to fight against a government entity when it comes to property rights? And the most common answer that I've heard on every question throughout the surveying program is it depends. Everything depends. Like I said, sometimes a taking can be beneficial to you. Sometimes it just isn't prudent to fight a property rights issue. And sometimes it is, sometimes it isn't, sometimes it just isn't so obvious. Every situation is unique, and we'll have a different answer for this. Like with exactions, for instance, depending on the project and depending on the developer, how big they are, like a big developer usually knows that they're just burning money until the project is finished. And so if there's some small exaction that's not legitimate, they will generally just pay for it because they know that if they hold up the project further, they're going to lose more money. But a smaller developer, say you just want to, you bought a couple lots and you just want to combine them or something, and there's some absurd exaction. Well, it'd probably be worth it to fight it then. We had a guy who was doing exactly that. He bought 2 lots next door to his house and he just wanted to combine them and build like a duplex or something on it. And the canal company said, well, that's great, but in order to do this, we're going to make you improve our canal. Even though it had nothing to do, our project affected the canal in no way, had nothing to do with our project. And we found it. We're like, well, we don't think this is legitimate. So all we did was we just contacted, the canal company, and we just said, we don't think this is legitimate. And we contacted the city. And after just talking to people and knowing our rights and knowing the laws, we were able to solve the problem. We saved the guy thousands of dollars, and all it took was just communicating and knowing what the laws are. And sometimes it just isn't that simple. Sometimes it is. It really just depends. If you end up getting into a lawsuit, that can be really expensive. Attorney fees are expensive. The other thing to consider is professional relationships. If you plan on working in a city a lot, you may not want to piss everyone off. You may just want to keep your relationships as good as you can and not go into litigation or anything like that. And it may just be worth it if it's something small to pay for it. You won't be able to make any money if your project is halted by legal issues. So really, it just comes down to weighing the pros and cons of every single situation. However, like I said, you can always contact the property rights ombudsman. They can give you an opinion on your specific case. And that honestly is your best resource in this state. Yeah. So that's pretty much it. I made a website as well. It's not finished exactly, but I can pull it up here. Can you see that, Dan? My website? Okay. So I just made a website, and I've taken articles, pieces of my report, my analysis. I've created little articles or whatever about those that are easy to understand, quick to go through, just take a few minutes to read. And then I've provided links to the Ombudsman, the Constitution, the Land Use Academy of Utah, and cases regarding property rights where people could search for situations close to theirs so that they can know what's going on. So if anybody has any questions, I'm happy to answer them. So.
Can you take us to one of those articles there?
Yeah, absolutely. Let's go. We can just go to this first one here. And I created all these images and everything, so.
Okay. So really just educational in nature is what you're trying to do there.
Yep, just educational pieces of my report. I'm going to have links to my full report once it's done. So if somebody wanted to read that, they can see, all the topics that I have here. Just quick educational stuff. So.
are you going to go ahead and still do an article?
Yeah, I'm planning on it. So,
okay. You guys have any questions for him, Parker? It's very informative. Very informative.
Yeah, I don't.
I think it was
very informative. Had a lot of information in it, so.
I think it was very, very good. We had experienced my own private property in Idaho where I had a power company come through with a big power line, and we had to have easements and compensation and damages, whole 9 yards, it seemed like. So, and I think that a lot of the neighbors, if they'd have been more educated like this, they wouldn't have had such a bad experience with it. I found that if you're willing to work with them and talk with them and negotiate, then it goes a lot better. But a lot of the neighbors got a attorney and they fought it and still ended up coming through their property, and they got a lot less than those who worked with them. So,
yeah, I mean, really, all you can do is be educated and know your rights and talk to people. Communication really is the main thing. Yeah, so sometimes it's worth it to just hire an attorney to just send a letter. I mean, sometimes that's the best way to do it, but yeah, just depends.
Defending your property is our right to do as well, and keep protect that. Sometimes people aren't trying to take advantage of it, but there are some people who do, and some public entities they try to take advantage of that situation. So it's helpful to know just where you're at. It's no different really than being just a neighborhood dispute over your property, where the boundary line might be or something. It's the same kind of idea. We need to be able to understand what the laws are and what we work with. We had somebody off over here not too far from us that they bought this property and thought that they could just start coming in and moving stuff around and putting a fence in, and it's like, which is fine, but they were like 5 or 6 feet into the next guy's property and didn't even bother talking to him or anything. And they were actually had contractor hired and were actually putting it in and digging up the ground and doing stuff. And it's like, wait a second here, that's not where the boundary line is. Well, the realtor told me that's where it was. It's like, well, there's more to it than that. So yeah. It's really, this is the same thing, only now you're dealing with public entity and trying to realize that there are some things in place in our laws, but understanding what those are and that they have to go through a process there. One of the things I thought was important, and that's why I was bringing it up, is the idea of taxation without representation. And essentially these exactions can be that way, but there is representation if it's done correctly. Sometimes we weren't necessarily in the public meeting when it was agreed, but when it's in code, those are things that are agreed upon. So that's kind of what I was wanting to bring out there. Sometimes we get this idea that the government's just doing all this stuff without following any laws, and sometimes they do, like this inspector wanted you guys to do a bunch of stuff. It's like, yeah, now you're going past what you have the right to do. But if you don't know that, then you just, you end up paying a bunch of money or something.
Yeah. So it's all about knowing. It's just about education. That's really all it is. That's what it boils down to. So.
Yep, exactly. Well, great. We're out of time here, and we've recorded this, so I appreciate being able to have access to that. And if you guys want to look at it, you're welcome to do that. We are done for today, though. So thank you very much, Parker. Appreciate it. Any last questions from you, Hunter or Clint? Either one.
Yeah. Could you put a link to his website in Teams or Canvas?
Yeah. I can copy it and put it in the chat.
That'd be great. Good idea. Thank you.
Let's see. How do I get to the chat?
It's the people. Well, actually, it's the little conversation bubble there up on the top next to your share.
No, I don't actually have that. That's interesting.
Oh, because you're coming in as a guest. All right. Well, email it to me and I'll get it to these guys.
Okay. Sounds good.
Yeah, that's a great question there, Hunter. Any other things before we exit out of here, guys? All right. Thank you again, Parker. Appreciate it. Great presentation. Learned a lot. Thank you.
Yeah, I'd love to. I don't know if you have a few minutes to talk to you after, but.
Yeah, hang around. These guys can go, though. That'd be great.
Okay.
Thank you.
Yep.
Thanks, Parker.
Yeah, thanks for listening.